blessings and guidance to organize this third national webinar series. Today, we are blessed to have Advocate Amrita Khalkar ma'am to be our guest speaker, who would be enlightening us on an overview of insolvency and bankruptcy code and need to revisit in light of COVID-19. I would now request Dr. Amrita ma'am to kindly take over the session.
Thank you, Pooja, for introducing me. At the very outset, I would like to thank KLE Law College for having me invited to deliver a lecture. So, in today's session, I shall be delivering a lecture based on insolvency laws. I have decided to divide it into two parts. Part one of the session will deal with the entire overview of the insolvency code, and part two will deal with the impact of COVID-19, the present scenario which we all are facing, and how it has affected the Insolvency Act.
Thank you so much, ma'am.
Surely,
But I'm just like, we both are having the same first names. So I think she had handed over the session to me to give. I just would like to take this privilege to give a brief introduction to you about you to our dear participants. Yeah. So thank you so much, ma'am, for accepting our request. And before I hand over the session to you, I would just like to give a brief introduction to our dear participants. Ma'am is the co-founder partner of law firm KV Legal. She has expertise in real estate and litigation. She graduated in law from Pune University, and thereafter she qualified as a solicitor and was thus granted membership of the Bombay Incorporated Law Society. She began her career by signing articles for pursuing solicitors with Malvi Ranchordas and Company. Gradually, over the years, she climbed the hierarchy in the firm from an articled clerk to senior associate. Her determination and vast experience in the field of law and her passion to work in the legal field resulted in her establishing her own law firm, and she has been instrumental in making a name for her law firm in the legal field. She has her expertise in drafting and vetting of agreements, deeds, conveyance, and incidental documents thereto. She also specializes in drafting plaints, pleadings, and other proceedings, and attended to matters before the DRT, NCLT, Consumer Court, City Civil Court, Bombay High Court, and the Collector. We are highly privileged, ma'am, that you have given us your time for KLE College of Law, Navi Mumbai. And with due respect, I would just like to hand over the session to you. Thank you so much, ma'am.
I hope I now start with the session.
Yes, of course. Yes, of course.
Okay. So, like I mentioned to you all, that I shall be dealing with this particular session and separating it into parts. Part one will deal with the insolvency code, and part two will deal with the impact of the COVID-19 on the insolvency code and the amendments that have come in place. So let's begin with what is the insolvency code all about. It has come into being in the year 2016. So while I'm going to explain to you, or rather give you an overview of this entire code, I would also like to share with you all a presentation which has been prepared to give you a better idea and an overview of the entire code. So I shall start with the sharing of the content. Just give me a minute. Is the presentation visible to?
Yes, ma'am, it is visible.
Yes, ma'am.
Okay, and is it the full screen? Because I'm just trying to figure that out.
It's properly visible, ma'am. It's full screen, visible to everyone.
Okay, fine. So then I shall continue. So this is about the Insolvency and Bankruptcy Code, which I'll be now giving you an entire overview. Before I give you the entire overview, I would first like to explain to you all what the three terminologies under the code are, which are very important and vital for us to understand the code. So the first terminology is the Insolvency Code, the Insolvency, second is Bankruptcy, and third is Liquidation. Now, what does insolvency actually mean? What is it all about? It is insolvency means the inability to pay the debts and liabilities which exceeds the assets. So naturally, insolvency will come into place when someone has borrowed monies and is unable to pay the dues. That is where insolvency will strike a person or a corporate entity. Now, what happens when it means bankruptcy? So, when a person is declared incapable of paying its dues by a competent authority or an adjudicating authority, is when we say that the person is bankrupt. So, prior to being declared bankrupt, it is what the person goes through is insolvency. So, it's insolvency, bankruptcy. And then comes a third terminology under the code, which means it is a process of winding up of a company on being declared bankrupt by a competent authority or an adjudicating authority. Now let's move on to understand the need for the code. Why did we feel that this law needs to come in? Now, prior to the insolvency code, let me take you back a few years where there were multiple laws in case of dues which were unpaid by the borrowers. Now, for example, there is a corporate entity, a company, and is unable to pay the dues which have been taken from a bank. Now, where does a bank go? So, today we have the Insolvency and Bankruptcy Code. But prior to this code, what were the different forums available to the bank in the event there was a NPA account or in the event the company is unable to pay the dues? So we had the SURFACI Act available for the bank. We had the recovery of the debts which were under the RDBBFI Act of 1993. Also, if a company was unable to conduct its business, there was an act which was called as a SICA of 1985, which came into being, and it was a body which was formed called the DIFR, which monitored and controlled the companies who were unable to do business in profits, which basically went under the law. Further, if individuals were to be declared as insolvent, then we had the Provincial Insolvency Act in place, the Presidency Towns Insolvency Act in place. So there were various enactments which were all scattered over, but there was not one consolidated act which gave the banks a way to proceed forward, not just the banks or the financial institutions, but also to service providers who were providing services to entities but were not able to get their outstandings paid from these corporate entities. We had a lot of forums for that. We had the DRT, that is the Debt Recovery Tribunal. We had the CLB. We had the High Court. We had the Appellate Tribunal. We have many forums. But then came this particular code, that is the Insolvency and Bankruptcy Code, which came into being and brought all these acts and kept them to one side and gave a very effective mode or a remedy by which companies which were trying to test the waters or unable to cope with the current economies are able to revive themselves. So now we move from the need of the code to the next slide with the object of the code. Now, what is the object of this insolvency code? What is the basic need the current companies or the individuals are facing? And this particular insolvency code not only caters to whose dues are pending, but it also is a revival or a breather for those corporate debtors who are unable to pay the dues. Now, why do I say it's a breather, or you can say it provides a relief to these corporate debtors? That we'll come to know while I'm explaining the entire slide. So let's first look at the objects of the code. Now, what are the objects of the code? The entire insolvency process has to be done in a very time-bound manner. It has to be in a very specific manner. It helps to promote entrepreneurship. Now, what do I mean promote entrepreneurship? That also will be very clarified in detail once we proceed ahead. But to just explain in short, entrepreneurship would be that in the event a company is unable to carry on its business, then a new applicant, or you can say a new investor, can come forward and help the company go ahead and take the company or continue with the business of the company. It also helps to balance the interests of all stakeholders. The another thing under the code is it clearly defines the order of priority. Now, when I say that it clearly defines the order of priority, means that in the event the company has to undergo liquidation, then who are the people who are supposed to get the monies first in point of time, then the second in point of time, and third in point of time. So this code is very clear as to how the payouts are to be done, how a workman has been placed under the code, how are the creditors placed under the code. Therefore, the object of the code is very clear that this is an entire process of resolution of the company. The code does not promote that the company should be liquidated and that the company should be washed out. What the code promotes is that the companies which are sick or the companies which are unable to sustain the current economy need to go ahead, need to go up, and therefore the object of the code. In order to better understand the object of the code, you can all refer to a judgment of the NCLT, that is the National Company Appellate Tribunal. In the case law is Binani Industries Private Limited versus Bank of Baroda, where it has been clearly stated the object of the code, which I am currently explaining to you all. We now move next section, that is applicability of the code. Now, what do I mean by applicability and why am I explaining this? Because the code itself has been divided into different parts. It has been divided into various sections. But please note here that many of the sections of the code are yet to be notified. So we have the code is applicable to companies registered under the Companies Act of 2013. We have the code applicable to the personal guarantors to corporate debtor, limited liability partnerships, partnerships and proprietary firms, individuals and bodies incorporated under but notified by the central government. But what has been currently notified is the companies and the LLPs. Further, guarantors to corporate debtor has been recently notified in December 2019. And this particular law is slightly untested in today's time. However, from my experience that I have been working with NCLT, there's humongous number of cases which are pending with regards to the revivals of companies and the LLPs. So this is roughly about the applicability of the Act. We shall now proceed to the next slide. Now, what I will be doing under this slide show is that the corporate insolvency resolution process is what will be explained. Now, since I've already mentioned that the code deals with a variety of aspects, but my today's presentation will deal or rather give you an overview of the corporate insolvency resolution process, which is the cream or the current feature which every individual or a lawyer needs to know what it deals with. So this corporate insolvency resolution process is applicable to whom? It is applicable to companies and to limited liability partnerships. So it's applicable to two. Now we shall now proceed to the next slide. So to understand the scheme of the CIRP process, that is the corporate insolvency resolution process, what we need to first understand that there has to be a debt. Now, what is a debt? A debt is a liability or an obligation which has been dispersed against a consideration for time value of the money. So this entire concept of debt has to be very well understood. Now, why is that we have to understand the word debt is because this act brings in a bifurcation in debts. One is financial debt and another is the operational debt. Now, what do we mean by a financial debt and what do we mean by an operational debt? Now, what is a financial debt? A financial debt is basically monies which have been lent by bankers, financial institutions to the corporate debtors, and an operational debt deals with deals with goods or services which have been delivered and monies have not been paid to these operational creditors. So once we understand that there exists a debt, so now there is a debt. So if there is a debt, we have to now proceed for the CIRP process. Now, how do we proceed under the CIRP process? We will first have to identify whether the debt is a financial debt or an operational debt. After understanding that the debt is a financial debt or an operational debt, you need to identify who you are against the corporate debtor. To understand who you are against the corporate debtor, you need to again classify yourself into a financial creditor and an operational creditor. So, of course, a financial debt will classify you as a financial creditor and an operational debt will classify you as an operational creditor. Now, what happens with a financial creditor? Now, before I begin explaining the entire process of financial creditor, operational creditor, and further on, let me tell you that this entire code gives a lot of weightage to financial creditors as against the operational creditors. So, this whole scheme of this code will revolve primarily around the financial creditor as well as the operational creditors, and the law is also quite evolving in this particular area. So in my personal opinion, maybe the law might see a shift or a change from the importance given to a financial creditor and the lesser importance given to the operational creditor, which may tomorrow might be placed on a same pedestal. But that, of course, is not tested with time, but it is evolving. But however, the current scheme as it stands is that financial creditors are at an upper pedestal as compared to the creditors. Now, what do the financial creditors do? Now, the financial creditors have to issue a demand notice to the corporate debtor. Now, issuing a demand notice to a corporate debtor, is this mandatory? Is this essential? Then, under the law, under the code, it is not a mandatory feature that demand notice must be issued to the corporate debtor. But if you consider a operational creditor, an operational creditor is required to give a demand notice, and that too for 10 days. That is, the corporate debtor has to revert on the demand notice within 10 days of the receipt of the demand notice. So, thus, a CIRP process can be initiated by a financial creditor and an operational creditor. The code further makes one more provision that it can also be initiated by the corporate debtor itself. But for a corporate debtor to initiate its own CIRP process, it has to satisfy certain tests. Now, what would be those tests? That the liabilities of the corporate debtor should be sufficient enough and should be met by the assets of the corporate debtor. Otherwise, the voluntary insolvency process would definitely not be available to the corporate debtor. Now, understanding who can initiate a CIRP process and what is a debt, we shall now move on to the next step that a person has to undertake. That is, where do I go to file a petition? What do I do? How do I approach the forum? Now, the forum for the purpose of an operational creditor or a financial creditor or for the corporate debtor under the code is the NCLT. Now, NCLT stands for the National Company Law Tribunal. So, a petition has to be filed with the NCLT for the purpose of getting the petition admitted and to be declared as an insolvent. Now, further, once we know where the forum is, that is the National Company Law Tribunal, two things primarily happen on filing. Now, what are those two things? Either the corporate debtors. So, if the operational creditor or the financial creditor files a petition in the court, then the corporate debtor has an option. I would not say an option, but I would say that can come forward for the settlement by payment of its dues. In the event the corporate debtor decides that no, it is unable to settle the dues and that the adjudicating authority, that is the National Company Law Tribunal, is satisfied that this petition needs to be admitted, this petition gets admitted. But bear in mind, it is very important to note here that NCLT or the Insolvency Code cannot be used as a recovery tool, because with my experience, or rather what I'm currently seeing, is that many persons, many creditors are approaching the NCLT only for the purpose of recovery of their dues. But this is not the motto of the Insolvency Code. And this is very well established in Mobilox Innovations Private Limited versus Kisura Software Private Limited. And it is a Supreme Court judgment which clearly states that this is not a recovery tribunal, and that if there exists a dispute between the parties, Insolvency Code cannot be invoked. It cannot be invoked under any given situation. Therefore, we must be very sure when we are invoking an insolvency against any corporate debtor, the creditor must be very sure that the dues are not able to be paid by the corporate debtor for reasons which are beyond control of the corporate debtor, or for reasons which the corporate debtor can then explain to the adjudicating authority. Now, what happens on admission of the petition? Four primary things that happen. First is the of the moratorium period, appointment of an IRP, third, insolvency commencement date, and the fourth is the directors of the company stand suspended. Now, I shall explain each and every aspect in detail in my subsequent slides, but primarily we have to understand that the insolvency commencement date is very important. That is, on the day of the admission of the petition, the timelines under the court are triggered, and therefore this date plays a very important role. Now we shall move to explain each of these four aspects. First comes the moratorium period. Now, what do you mean by this moratorium period? Now, let me tell you one thing, that this moratorium period is actually a breather for the corporate debtor. Now, why would I say that it is a breather? In fact, insolvency means that the company has to come down to a standstill. But no, a moratorium period has come into being. Why? Because all institutions of suits and proceedings against the corporate debtor, which are civil in nature, mind me, they are civil in nature and not criminal, against the directors, all civil proceedings come to a standstill. They are stayed because of this moratorium period. So nobody can file a suit or continue a proceedings against the corporate debtor. There can be no transferring or disposing of any assets of the corporate debtor during the moratorium period. Also, this particular moratorium period is applicable to the SARFAESI acts which the banks invoke against the corporate. Also, one important point which is very important to note, that recovery of any property by any owner where the property is occupied or is in possession of the corporate debtor cannot be invoked. So in the event, like let's take an example, that there is a corporate debtor who has a property which is on leave and license basis. The registered office is in the leave and license premises. Now this property cannot be taken by the licensor back only because the moratorium has been set in. The licensor has to wait for the entire CIRP process to get over. Therefore, moratorium period gives a breather to the corporate debtor to revive itself, gives a chance to the corporate debtor to continue its business. Now, how is this chance given to a corporate debtor to continue its business? I shall explain in due course. But it is a period where all proceedings against a corporate debtor get stayed. We should now move on. How long does this moratorium period last? Now, this moratorium period lasts till the entire CIRP process is completed. Once the adjudicating authority, that is the NCLT, passes an order that the company is revived by virtue of the various plans which I shall explain, or it has to go under liquidation, then in that case, what happens is that this moratorium period shall come to a standstill. We shall now move on to the next slide. The second thing that I mentioned earlier, that on admission what happens is an appointment of a person called as an interim resolution professional. Now, who is this interim resolution professional? He is a person who is registered with the Insolvency and Bankruptcy Board of India. Now, these are the persons who take over the management and the control of the company. They play a very vital role under the code. These people are supposed to be considered as the directors of the company, but not in its actual sense. They are the ones who continue the business of the company. They are supposed to take over the property and the assets of the property. They take the possession of the property. They have to take into consideration all the accounts. They're supposed to manage the employees and the managers of the company. They sit on the wheel, the steering wheel of the company. So what happens is that the directors are no longer running the company. It is the interim resolution professional who has to run the company. Now, this interim resolution professional, there are various duties casted upon this IRP. If these duties have been flouted, or the IRP violates the code, then complaints can be made to the IBBI, that is the Insolvency Board, for the purpose of replacing the IRP, taking a disciplinary action against the IRP. Now, when I say that a disciplinary action against the IRP has to be taken, you really have to show that the code has been violated. Now, there have been instances, let me explain to you all by way of examples, or where we have actually dealt with cases where we have appeared on behalf of the suspended directors, where we had to file an application before the NCLT saying that the IRP is not conducting its duties and violating the principles of the code. Now, we had made this kind of an application before the court for the only reason that the IRP was not attending the company's office, had not taken into consideration the various accounts of the company. The IRP had also not taken into consideration the properties which were leased out to many licensees, the properties which were also taken on lease by various lessors. So therefore, the IRP had to be replaced. The IRP was to also change, the disciplinary committee had also had to come into being for the purpose of the IRP to be replaced. Now, what happens further? The IRP has certain duties which it has to follow under the code. There are certain regulations which have been listed. Now, few regulations of the IRP would be that as soon as he assumes office or takes over the management, he has to invite claims. He has to take over the various assets of the company. And once he does that, he has to formulate a committee of creditors. The committee of creditors plays a very vital role because it is this committee of creditors which will decide whether this particular IRP shall continue with the entire CIRP process or they shall appoint a new RP, that is the new resolution professional. So I'll take you to the slide which deals with a resolution professional. Now, this resolution professional is appointed by the committee of creditors which was constituted by the IRP. So either the IRP only continues as the resolution professional, or the new RP is appointed in place instead of the IRP. The duties remain the same and the obligations of the IRP continue to remain same. I've listed a few of those obligations here which says that the RP shall conduct the entire corporate resolution process and manage the operations of the corporate debtor during the CIRP period. The RP shall give notice of each meeting. Now, bear in mind here again, when I say that the RP shall give notice, now this mode of giving issuance notices or the minutes of the meetings to be maintained by the RP are something which have to be maintained. If they are not maintained, then it is a violation of the code. Now, when I say that this is a violation of the code, that means this committee of creditors is required. This RP is required to give a notice of 5 days. This RP is required to maintain the minutes of the meetings. It is required to issue notices to the suspended board of directors. But if all these parameters are not done, then the entire CIRP process is hit by irregularity. Therefore, many petitions in the court are currently pending on the grounds that the RPs have not conducted the CIRP process and faces a lot of irregularities. We shall now proceed to the next which gives you a general overview of the various steps that the the RP is required to do. So basically, there'll be a public announcement by the RP. After the public announcement, the RP is required to appoint two registered valuers for the purpose of the valuation of the corporate debtor. Now, what is important here is that this particular valuation, what is important? The valuation. The done by the registered valuers of the corporate debtor has to be maintained by high levels of confidentiality. It cannot be disclosed to anyone. This is the liquidation value of the company, and it will decide whether the company can be revived or cannot be revived after it receives plans from prospective investors. Further, once this entire chart that I've placed before you all will give you how the role of the IRP and the RP comes into being and what all provisions under the code have been given to the RP to take charge and control of the corporate debtor. The RP is also required to invite claims. The RP is also required to give an information memorandum to people who are interested in continuing the business of the company forward. So all these aspects are very important from the point of view of an IRP or an RP. Now, certain concepts under the code are very important to be understood, which I shall deal with in detail. Now, let's look at the first concept, that is committee of creditors. Now, this committee of creditors, as I've initially explained, that it only consists of financial creditors of the corporate debtor. So these financial creditors are the ones who decide or take the decisions for the purpose of conducting the business of the company. Now, this particular RP is acting as a mediator between the committee of creditors, the suspended board of directors, and the new investor if interested in the company. Now, the committee of creditors is required to be having a voting power for the purpose of deciding anything. And that ratio has been decided at 66%. So anything that has to be passed through the committee of creditors have to pass the 66% threshold limit. This committee of creditors, one important thing that has been handed over to them is the approval of the resolution plan. Now, what do I mean by resolution plan? I shall explain it in detail, but to give you an idea, a resolution plan is the revival of the company. Now, this particular revival plan has to take into consideration various aspects, that is how much monies need to be infused into the company, how much monies are to be given to the financial creditor, the operational creditor, the other debtors, and the other creditors of the company. So this particular resolution plan has to be approved by the committee of creditors, and this has to be then approved. This particular plan has to be then approved by the adjudicating authority. But what will the adjudicating authority look into? They shall not look into the commercial wisdom of the resolution plan, that is, how much monies are being paid to the financial creditor or the operational creditor. They shall see that this particular resolution plan satisfies certain criteria which are more technical in nature and listed out in section 30 of the code. And therefore, there is a case law of the Supreme Court, that is case K. Shashidhar versus the Indian Overseas Bank. Now, this particular case law has laid down a ratio which is very clear that the commercial wisdom of the committee of creditors cannot be challenged, and therefore a plan which has been approved by the COC has to be approved by the adjudicating authority. But bear in mind that this cannot be a blanket provision. There has to be a tap on how this resolution plan comes into being, or whether it is feasible for the company to continue as a going concern. So this is all about the committee of creditors. We should now come to the next aspect, which is the resolution applicant. Now, who is this resolution applicant? This resolution applicant is the one who would be interested in the affairs of the company. Now, who can file a plan, or who can come forward as an investor to continue the business of the company, or who can think of revival of the company, has been laid down in section 29A of the code, which clearly mentions the criterias and the I would say the particular criteria required for the investors or for the person to take over the company, or the eligibility criteria. So there are various eligibility criteria which have been listed. One being that the investor should not be a suspended board of directors. However, if it is an MSME company, then it can provide the certificate and satisfying certain criteria and payment of certain dues. It can put forth its resolution plan. Then you have the RP. The RP cannot, or the IRP cannot become the resolution applicant. So there are various criteria which have been laid down. So this resolution applicant has certain rights. It can go before the COC, explain its resolution plan. However, it will not have the right to vote in any of the COC meetings. It shall only be present in the COC meetings for the purpose of the plan only, and not for any other businesses that are transacted during the meeting. So this particular resolution applicant is required to remain present and is required to be issued the notices at the time when the COC shall conduct the meeting for the purpose of discussing the resolution applicant's plan. So resolution applicant plays a very vital role. This is where the code is very important. The object of the code, that it promotes the company to go on. It is not a sale of the company. There is a case law of Binani Industries Private Limited versus Bank of Baroda, which has clearly stated that when the management is changing from the suspended board of directors to the new resolution applicant, it cannot be a sale of the business. It is not that they are purchasing the assets of the company. It is that the company shall continue with the same business, go ahead and take the company out of the debts that it has got into. So this is called as the resolution of the company, and that is what the object of the company is all about. Then comes the resolution plan. So resolution plan is something which is very important, which has to satisfy many criteria. When it is tabled before the COC for its approval, the COC shall require the resolution applicant to amend it or make certain changes which are in favor of the committee of creditors. Again, what I would like to highlight is that the committee of creditors is only of the financial creditors and not the operational creditors. So it might consider its importance or how their dues are being settled first as against the operational creditors. But then there are judgments of the Supreme Court which state that operational creditors need to be placed on an equal footing, needs to be considered, all stakeholders need to be considered. So it is very important that a resolution plan to satisfy all the requirements of the code needs to cater to all the stakeholders. That will be the plan, which means the actual resolution of the company. Now, what happens when the resolution plan is tabled before the COC? It either gets approved by the COC or it is not approved by the COC. Now, there are many resolution plans that come. So, the COC has to decide amongst so many resolution plans, one resolution plan, which is the fittest resolution plan for the survival of the company. And then it has to be approved by the COC or it cannot be approved by the COC. Now, it can be either approved by the COC or it cannot be approved. Then, once it is approved by the COC, the RP seeks the approval of the NCLT. NCLT, that is the National Company Law Tribunal. The NCLT again shall approve the plan or not approve the plan. Generally, the commercial wisdom, if it's into consideration, the NCLT shall not look into those aspects, but it shall reject the plan if there are grave irregularities in the way the CIRP process has been conducted or in the way the resolution plan has been tabled before the COC. So if a resolution plan gets rejected and the company does not have a resolution plan, then what happens is that the company goes into liquidation. Again, if the COC also has not approved any resolution plan, then also the company moves on to the liquidation of the company. So this is where once the resolution plan is accepted or rejected is when the CIRP process comes to a standstill. But this particular CIRP process or this timeline is very a mandatory timeline which we cannot afford to forget because these are the mandates of the code. This is why the code is considered to be the most important part where the timeline becomes the essence of the code. So what are those timelines? So generally, a CIRP process continues for a period of 180 days plus a 90 days extension is given for reasons which have to be tabled before the adjudicating authority, which will then take the CIRP timeline to an entire timeline of 270 days. So 270 days is the actual timeline, but the code further makes a provision and it says that it has to be 330 days mandatory period. Now, when it says 330 days, what do we understand by that? If we are saying 270 days and then further a 330 days, there has to be some correlation. So what 330 days tries to imply is that the entire CIRP process, along with any kind of a legal proceedings that come in between, will be considered but cannot go beyond 330 days. So ultimately, the entire CIRP process, be it applications to the NCLT or be any kind of a proceeding, the entire process has to be completed within a period of 330 days. We shall now move on to the next slide. Now, what are the various forums which I've already explained? The first thing that a petition has to be filed in the National Company Law Tribunal. If an order is being passed by the National Company Law Tribunal, the same has to be appealed, and if it has to be appealed, it has to go to the National Company Law Appellate Tribunal. Now, again, there is a limitation given here, which is a period of 30 days. Further, an order of the National Company Law Appellate Tribunal can further be appealed, and the appellate jurisdiction is the Supreme Court. There again, the limitation. Have a clear-cut scheme that goes right up to the Supreme Court, first being the NCLT, then coming this NCLT, that is NCLAT, that is the Appellate Tribunal, and the third last forum is the Supreme Court. Now, I shall take you to the next step. Till now, I've explained to you the entire CIRP process, the entire resolution plan as to how the company can be resolved, how the company can come into action, how the company can be a going concern once again. But in the event the company cannot be revived, there is no resolution for the company, then what happens? Then the company has to go under liquidation. So here I've just quickly laid down the process of liquidation, which gives you an idea what happens in a liquidation. So once the insolvency process is over and that there is no resolution plan in place, that is the company not being revived, then the company goes for liquidation. On company going for liquidation, there is an appointment of a liquidator. The liquidator again makes out claims, calls for claims, invites claims, verifies the claims. Again, there is a period of moratorium under liquidation where you cannot proceed against the company. Then there is the issuance of public announcement. Then what actually happens is that the entire assets of the corporate debtor are pulled in together to identify how the payouts have to be made. So the entire monetization of the assets and distribution of the proceeds have to take place. And finally, on distribution of the proceeds, dissolution of the corporate debtor comes into action. Now, how does the distribution of proceeds happen? Like I mentioned earlier in the object of the code, first and primary thing is that the priorities are very clear under the insolvency code. Section 53. I shall now take you to a concept called as a waterfall mechanism. This is a waterfall mechanism here, which gives you a very clear understanding that under a liquidation process, the payouts to various parties have been laid down under the Act, and it creates partitions between the various creditors of the company. So the first and foremost payout shall happen to the insolvency resolution and liquidation cost. It is first that the costs get paid under the waterfall mechanism. Thereafter, it is the secured creditors if they have not relinquished the security, and the workman's dues for a period of 24 months preceding the liquidation commencement date. Thereafter comes the wages and unpaid dues of the employees, then the unsecured creditors, and then comes the central and the state government dues and the secured creditors for an unrealized amount of enforcing the security interest. So if you see the waterfall mechanism, you'll see that the government dues, you say that there is a TDS pending or there is any service tax pending or a GST now which is in place, those taxes will be placed quite later in point of time as against the secured creditors, as against the workmen's dues, which have been come up way ahead in the waterfall mechanism. So this particular slide has given you an entire idea as to how the assets of the company have been distributed. So with this, I shall now my segment of the insolvency process. I shall now take you to the next segment of my session, which is the current COVID-19 situation which we all are facing, and that would be the amendments which have come into place because of the COVID-19. Let me just pull on the slide for you all. Now I shall deal very quickly with the impact of COVID-19 on the IBC. Now, why am I going to deal with this particular aspect is because it has really brought in certain fundamental changes to the code. It has triggered various aspects under the code. So let me pull on to the slide which deals with the impacts. COVID-19 impact. I shall not get into a lot of details as to the various amendments that have been carried out, but the primary three amendments which I feel are very essential for each one of us to today understand and explore those amendments. The three amendments are that the minimum default has been increased from increased to rupees 1 crore from rupees 1 lakh. Secondly, there has been relaxation in timelines under the IBC. And third is a suspension of section 7, 9, and 10 of this for a specified period. Now, let me pull on to the next slide. Now, increase in the minimum default. Now, as we have seen that for a debt which has become due and payable, and a financial creditor or an operational creditor has to trigger the insolvency code. Then what is the minimum amount of debt? So under the code, the first amount mentioned was rupees 1 lakh. So if the debt due was rupees 1 lakh, a creditor could invoke the insolvency code. But this particular 1 lakh has now gone to 1 crore of rupees. Now, why has this change come in? This change had to be brought in because of the current economic conditions of our country. We have seen that many businesses have come to a standstill. We have to revive our economy. We have to make the economy strong. And maybe that were the reasons why this particular amendment was carried out to section 4 of the code. Now, when I say what are the impacts, was this a positive impact? Was this a negative impact? So here I've laid down certain positive impacts, certain negative impacts. Now, what were the positive impacts? Relief for the MSMEs. Relief for MSMEs, that is the micro, small, medium enterprises, they stand to benefit because generally they would have small debts which will be of say 10 lakhs or 16 lakhs or 20 lakhs or 40 lakhs. So such creditors will not be able to invoke the insolvency process. If they can't invoke the insolvency process, these MSMEs will be able to revive their business. So it gives them some breather, it gives them some relief. Thereafter, we have a negative impact on what? We have a negative impact on the operational creditors. Now, when I say operational creditors, if a corporate debtor has defaulted in payment of goods and services of rupees 10 lakhs, so those rupees 10 lakhs would then become due and payable, but the operational creditor cannot invoke the insolvency code. The reason being that this particular 1 lakh or 10 lakh of rupees does not qualify the threshold limit, and therefore the operational creditor will not be able to invoke the insolvency code. Further, this particular amendment has been brought in only in the corporate section and not under the personal guarantors to the corporate debtors, which threshold limit is still as low as 1,000 rupees, and therefore this will be negative, because if people can't invoke the corporate debtors insolvency, then they shall shift to the personal guarantors of the corporate debtor. So this will kind of create a negative impact, and therefore these positive negative impacts have to be taken into consideration to understand why the purpose of 1 lakh has been increased to rupees 1 crore of rupees. I have further laid down a few illustrations here as to what becomes the trigger point for IBC for financial creditors. So if creditor and I have to invoke the IBC. So if I have to invoke the IBC, my debt has to be clearly above 1 crore of rupees. So my first illustration deals very clear. It says that there was a debt of 5 crores and therefore the bank can invoke the IBC, can file a petition. But in my second illustration here, I've said that there has been a company, there's a financial creditor who has 10 lakhs debt, and there's one more financial creditor who has a debt of 5 crores. So if both the financial creditors can come in together, then of course the creditor will be able to file an IBC proceeding. Which creditor? The creditor who has to secure his 10 lakh of rupees, because under section 7(1) of the code, the financial creditor can file an application towards its own claims or aggregated claims of the financial creditors. Illustration 3. That is also very clear that in the event the company has defaulted bank A of rupees 60 lakhs and other financial creditors a total of 30 lakhs. Also, the company has defaulted operational creditors of rupees 60 lakhs. Then in such an event, can bank A still approach the NCLT? Bank A cannot approach the NCLT because the default is only of 60 lakhs, because section 7(1) only deals with financial creditors aggregation of claim and not that of the operational creditors. Therefore, it is very essential that this particular illustration is also important to understand the operational creditors and financial creditors, can they aggregate the claims. Moving on to the next is the trigger point for IBC for operational creditors. Now, it is very clear that the operational creditors can trigger the IBC only if their debt is due, above 1 crore of rupees. But can the operational creditors who have various amounts, that is 30 crores, 40 crores, 50 crores, or say, let's go into the lakhs part of it, say it is 30 lakhs or 75 lakhs, but does not aggregate to an entire amount, then can we go ahead with the filing of this complaint? Then no, because operational creditors together cannot have the aggregation together. We shall now move on to the next slide. Now, the applicability of this trigger point, that is 1 crore of rupees. What happens to the existing cases? Now, what happens to the existing cases is that demand notice served, but petition has not been filed prior to this particular amendment coming into being. Then it seems difficult that the petition will be permitted to be filed. If the filed petitions are there, but they are pending the admissions, then it will be difficult for the purpose of file petitions to understand, because this is quite an untested law, and the court may give an opportunity to the creditor to increase the threshold if at all the threshold can be increased. And as far as admitted petitions are concerned, the trigger point remains as it is. There will not be, these cases will remain unaffected. It will not be affected by virtue of the trigger point or the virtue of this new amendment. Now, going on to the next timeline. What is the next relaxation in timelines? Now, by notification dated 29th March 2020, the period of lockdown has been excluded from the computation of the timelines under the CIRP. However, it is to be noted that this total CIRP period of 180 or 270 days shall not be extended by virtue of the exclusion of the lockdown period. Therefore, it is very important for us to understand that lockdown period can be considered for the exclusion, but under no given situation can the entire CIRP period be extended. So, if the RP has to carry out its duties during the lockdown period, it will carry out the duties. It will have to carry out the duties during this period, unless there are certain duties, say for the public announcement under the lockdown where publications have to happen in the newspapers, then those timelines can be increased under the code. But if you go to see the entire CIRP process, the entire CIRP process cannot be extended. We shall now move to the next. Now, this again is one very important amendment to the IBC. And I would say this is one of the most unprecedented amendment which has come to the IBC. It is the Ordinance of 1st June 2020, which has broken Section 10A, and it has suspended Section 7, 9, and 10. Now, when I say that it has suspended Section 7, 9, and 10, that means it has suspended the filing of petitions under by the financial creditors, the operational creditors, and the voluntary corporate debtors. So when I say suspension, that means that this particular filing process from the period of 25th March 2020 for a period of 6 months or such period as may be notified will be called as a specified period, during which it will not, no petition can be filed for any default that has occurred during this period. Now, mark my words, for any default. Now, when I say any default, it is to be noted that this default is very important, that it has to happen only within this period. Now, when I say that this particular amendment is an unprecedented amendment, the reason is that for the first time, the proviso which has got added here is that no application shall ever be filed for initiation of CIRP for a corporate debtor for the said default occurring during the specified period. So, after the expiry of the specified period, then also you cannot file for any default, any petition for a default that has occurred during this specific period. So, this means that no inquiries or no investigations can happen for the period during which this specified period is in existence. So this is something which is unprecedented. If you look at the international laws, this generally would not have happened in many of the countries like Singapore, where the insolvency laws have made it very clear that it will be for a specified period, but if the default continues, there might be an invocation of the default has happened during the lockdown. But this one period which has come forth here is something which is very striking, that you can never ever file for a default which has happened during this particular period. Now, further here, I would like to add one more point, is that what happens now for the specified period? Where do the banks go if there is a default? Where do the creditors go if there is a default? Then they have to explore other remedies. Like they'll have to file summary suits for their money. They might have to file, might have to go to the DRT. They might have to go to the various other places, forums where the debts can be recovered. So this will include the other forums again to come into picture for this particular specified period, as those forums have not been barred for the purpose of initiation of any proceedings for a default that has occurred during this period, as it only restricts itself to the insolvency code. Therefore, the suspension of section 7, 9, and 10 for a particular period, that is a specified period, is another important amendment that has been brought in under this code. I shall now take you to my last part of this entire slide will be the limitation. Now, when I say limitation, the Supreme Court has, by an order of 23rd March 2020, which is a suo motu order, has relaxed the period of limitation for all proceedings under the general special laws, everything with effect from 15th March 2020 till further orders. So, this relaxation is available only for appeals and applications under the code. But mark my words here again, relaxation does not increase or relax the CIRP timelines. These timelines are the code timelines which have to be followed, and they would not fall under the purpose of the limitations, as this limitation will be applicable only for the purpose of filing appeals or applications under the various sections of the code. So this brings me to the end of my session as regards the new amendments are concerned for the Insolvency Act. So I would request Amrita to.
Yes. Thank you so much, ma'am. Thank you so much, ma'am, for giving a wonderful insight on insolvency and bankruptcy code and relating it to the current pandemic situation. It has been really helpful for all our dear participants. I can see that in the chat, they are giving you so many compliments and thanking you for giving a wonderful insight on the very relevant issue. Ma'am, with your permission, can we just start with a question answer session?
Yes.
Okay, ma'am. I think I have to, ma'am, if you have to stop sharing the screen so that you're visible to everyone.
It would be the.
Should we start with the session, ma'am?
I'm just shutting down the sharing of the content.
Yeah. Meanwhile, I would just like to request our dear participants to kindly be patient. Ma'am will be soon there, and we'll be starting with the session again, question answer session.
Yes.
Yes,
Yeah.
ma'am, the slide is not there now.
Yes.
Okay, ma'am. So I'll now take up the very first question. It has been asked by Raman Sharma. He says that does the code is deficient in providing criteria for the qualification of the interim and of the final insolvency resolution professional?
So if I'm given to understand that, is there a criteria for determining who shall be the IRP or the RP? Is it?
Yes, yes.
So this particular criteria has not been laid down by the code, but there are various regulations which have been enacted by the IBBI, that is the Insolvency Board, which lays down the criteria. They have certain examinations which you have to qualify as a resolution professional and be registered with the IBPI. And it is only those people they take up this particular profession. And it is a financial creditor or the operational creditor who has to name the IRP or the RP in the petitions. However, it is mandatory for the financial creditors to name the IRP, but it is not mandatory for the operational creditors. And the adjudicating authority can themselves give the name based on the lists available with them.
Okay, ma'am. Thank you, ma'am. Another question has been asked by Raman Sharma. He says that does the code leaves no scope for settlement once the application is admitted?
So yes, there is. Now I will dwell into this by virtue of section 12A, which is under the code for withdrawal of the petition. Now it clearly says that once the committee of creditors has been formulated, you need the approval of the committee of creditors, that is 66% voting, for the withdrawal of the petition if it has been admitted. Also, if the COC has not been appointed, then we have dealt with matters where the COC has not been appointed, but the petition needs to be withdrawn. Then, in that case, the adjudicating authority has inherent powers, which inherent powers can be utilized by the adjudicating authority to withdraw the petition. But if the COC has been formulated, then yes, there is a particular procedure, that is the entire 66% has to approve the withdrawal.
Okay, ma'am. Another question has been asked by Puneet Gupta. He says that in case corporate debtor pays outstanding the dues of financial creditors, then what is the procedure?
As in, when would the corporate
think
the financial creditors, as in what are the timelines?
Yeah.
No, can you repeat the question again?
He's asking, like, in case a corporate debtor pays the outstanding of dues financial creditor of the financial creditors, then what is the procedure?
But then in that case, if the, like I mentioned, if the petition has been admitted, then the withdrawal option is available as mentioned under the inherent powers, or it has to go to the COC for its approval. And if prior to the admission there is a settlement of the dues, then of course the petition need not be admitted and it stands withdrawn with very easy implications.
Okay, ma'am. Another question has been asked by D. Jyoti Lakshmi. She says that why some of the provisions have not been given effective way by way of notification, and are there any conditions or contingencies under which it should be notified?
So certain provisions are not yet notified, as these provisions are to be notified. So the corporate insolvency has been notified till date. Currently, we have the personal guarantors which have been notified. Since this is a law which is in its nascent stage, it's an evolving law. It needs to test the waters. Therefore, it may be taking the time to go and understand each level of insolvencies with regards to the corporate debtor or be the personal insolvent persons.
Okay, ma'am. Another question has been asked by Vijay Lakshmi Raju. She says that what is the threshold limit for making an application for insolvency and liquidation of corporate persons?
So, like I've already explained to you, the initial, prior to this pandemic, the initial threshold limit for making an petition was 1 lakh, which is now stands increased to 1 crore. And I've explained that well in detail as to what that 1 crore today stands at. So, therefore, this 1 crore has to be taken into consideration for financial creditors separately and for the operational creditors separately. So, today we stand at 1 crore till it is further notified.
Another question has been asked by Srinivas. He is asking, will the minimum default amount be revised once the economic conditions improve?
It will be revised once the economic conditions will go back to normalcy, because we see that today when it was 1 lakh, that is when the code was enacted, we have seen number of petitions which have been filed, and we have also seen the positive side of the code, that there are so many companies which have revived, resolutions have happened for many corporate debtors. So it is a very good code, I would say, for the purpose of corporate debtors, and hence it is essential or rather for the upliftment of the economy. Today, 1 crore may be the case, but then once the economy has settled and stabilized, it may go back.
Yeah, ma'am. Thank you, ma'am. Another question has been asked by Brahmanand. He says that why is need of NCLT court when in civil court we already have commercial courts also?
So again, like I would like to say here that this is a question of dispute. If there is a dispute, then of course you have the commercial jurisdiction. That is, the commercial courts are available to you all. But if there is no dispute and the corporate debtor is unwilling to pay his debts and is acknowledging the fact that the purpose of this code needs, the company needs a revival, that of course is not going to happen under the commercial courts. That of course will happen under the insolvency court. So insolvency is not a recovery tribunal, as I explained. It is a resolution forum. It is a revival forum, and therefore the need of the code or the need of NCLT is very much important from the point of view of commercial courts, because commercial courts deal only with the aspect of recovery, whereas NCLT does not deal with the aspect of recovery. And this has been laid down in various case laws also. Also mentioned that Mobilox Innovative Private Limited has mentioned that this is not a recovery tribunal and it's a Supreme Court judgment.
Okay, thank you so much, ma'am. Another question he has asked, like, why is the need of Insolvency Bankruptcy Code 2016?
Why is the need?
Yeah.
So I've already explained to you in my slide, which my slide itself named the need for the code, which clearly mentioned that prior to the code coming into picture, we had a lot of enactments, various forums, and hence it was very difficult for each one of us to go to these various forums or to be aware also of these forums, or they are very time consuming because they ultimately become the courts. Whereas if you see the insolvency code, the timelines are highly mandatory and have to be followed. And therefore, it is essential that this code came into being because of the various codes that were there previously.
Okay, ma'am. Thank you. Another question has been asked by Prakash Kumar. He says that under what circumstances can one file bankruptcy in India?
Under what?
Under what circumstances can one file bankruptcy in India? And he also asks, how is it done? If a company becomes bankrupt, how they can pay staff the salary and their monetary obligations?
So, like I explained to you, that you have the financial creditors or the operational creditors of the company will naturally take the company to the NCLT for the purpose of being declared as an insolvent. And once the company gets declared insolvent, the question of payment of dues to the employees or everything becomes the headache of the RP who has been appointed. And therefore, the fact that these financial creditors or the operational creditors are the ones who take the corporate debtor to the NCLT. Now, the corporate debtor will also take you to the corporate debtor can also file for his own insolvency. But then again, there has to be that the liabilities have to be met by the corporate debtor prior to being declared as an insolvent. So it is always essential that, it is very important for us to understand that who can file the NCLT proceedings, the financial creditor or the operational creditors who can take you to the court.
Thank you, ma'am. Another question has been asked by Shreya Gupta. She says that who can file a complaint against the non-working or inefficiency of the RP or IRP?
So any person aggrieved by the IRP or the RP can file the complaint to the IBDI. So you can have so who will basically be aggrieved? The promoters, the suspended directors of the company will be primarily aggrieved because the RP would have destroyed maybe the assets of the company, or have not taken into consideration the recoveries, or would have diminished the value of the assets, because the entire purpose of the code is maximization of the assets of the corporate debtor. So if all these factors are not taken into consideration, then the suspended directors, because they are the ones who know their company very well, so they will be primarily affected. Then again, you will have the resolution applicant. Suppose the resolution plan which is tabled before the COC is not properly tabled, or there you find certain irregularities, or there is conflict of interest involved, then the resolution can also complain. The committee of creditors can also complain against the RP. So there can be many aggrieved persons in this particular criteria.
Thank you, ma'am. Another question has been asked by Anup Yadav. He's asking, can Supreme Court exercise its inherent power under Article 142 to enhance CIRP period?
No, they will not be, because this is a very special code, and this code has made it very mandatory, the guidelines and the timelines under the code. So therefore, for the Supreme Court to the Supreme Court will never go against something that has been laid down by the Central Act itself. So it will be very difficult for the Supreme Court to invoke its own jurisdiction to change a law which is already well settled.
Okay, ma'am. Thank you. Ma'am, another question has been asked by Sanjeev. He says that if demand notice is issued by an operational creditor prior to threshold limit being increased, what is the remedy?
Demand notice. So actually, this again is it's in the untested waters. But as I see it, and as in my personal opinion, if there is a demand notice, it's quite clear that if the demand notice is prior to the threshold limit being increased, then the application will not be able to be filed if the application is not filed.
Okay, ma'am. And a question has been asked by Anup Yadav. He is asking, what are the major drawbacks of the code?
So the drawbacks, every code has a drawback. Every code has its pros and cons. But if you go to see a drawback of a code per se, it will all depend upon how you look at the act. It is again the resolution plan, whether the revival, the drawback, like I mentioned, in my personal opinion, if you go to see financial creditors have been placed at an upper pedestal as compared to the operational creditors. So financial creditors are the banks. So are the banks in that position to understand whether this company has a viable business or no? I believe that the operational creditor shall be in a better perspective or in a better position to appreciate the business as against the financial creditors. But however, the code makes a provision to treat financial creditors better as against the operational creditors, and therefore they are the ones who form the COC. So there are certain irregularities. I mean, I won't say irregularity. There are certain loopholes, but then of course you have the law which has to be interpreted and evolving, and it will test the time.
Okay. Thank you so much, ma'am, for answering those questions. And indeed, our participants have benefited a lot from today's session. I would now like to, thank you, ma'am. I would now like to hand over the session to Pooja, ma'am, so that she can carry forward the event as scheduled. Thank you.
Thank you so much. Thank you so much, ma'am. Thank you so much, Amrita, ma'am, for having such an elaborate and comprehensive answers to the questions of our participants. Now, I would request our principal, sir, to kindly address our guest speaker and participants.
Thank you, Pooja.
Yes, sir. Yes, sir, you're audible.
You're audible, sir.
Of the entire KLE family, I would like to thank Amrita Kharkar for gracing today's session and sharing her views. We are now coming up to the third series which has started. But before that, let me bring it on record that Amrita Kharkar and a very intelligent women and has been participating in a lot of moot court competitions, debate competitions, and she is doing very well. And the bankruptcy code and everything, and she has not shied away with any question. And have your lecture. And I would like to be thankful to you on behalf of KLE Law College for joining this. And there are many more to come, and we would be very happy to invite you further sessions. Thank you. We were having
grateful for that.
The third national webinar series. Yeah. Sure, madam. Thank you. This third national webinar series, which started from July 2nd, we witnessed personalities like senior advocate Firdos Karachiwala, advocate Pramod Kumar Dubey, then advocate Saurabh, Shri Jitendra Verma, Mr. Shwetank Mishra, Professor, and definitely, and of course, our guest speaker for today, Amrita Kharkar. I'm also obliged to the KLE management to have this webinar series. Who is a chairman of a KLE society, who is a source of inspiration for us. Then Mr. Mahantesh Kaudigimat sir, who happens to be the GB chairman, that is governing body chairman of KLE Law College, as well as Karnataka government and MLC, Bharatiya Janata Party, the ruling party in Dr. Mallikarjunaya, principal KLE College of Law. And we are coming to end of this third. Overwhelmed by the success of first and second webinar series. Thankful to all the participants, and let me record that there were participants from Bangladesh, Nepal and Bhutan, and many other countries as well. So I'm happy for that. Not only that, but I am also thankful to my team, that is Dr. and Pooja Bijjargi, who have worked very this webinar series successful. They were a speaker and arranging, the coordination and everything. They have done a very great job to the institute. Not that, but also our two student conveners, Roshan and Shama, who were there at their best country, and for so I'm thankful to one and all other professors. Professor Salim Khan and Professor Srividya. So I thank you. Now I have this session to Pooja Bijari, Professor Pooja.
Thank you so much, Principal Sir. Thank you so much. On behalf of KLE family, I would again like to extend my heartfelt gratitude and sincere thanks to Advocate Amrita Kharkar ma'am for educating all of us with such an insightful session on the topic of insolvency and bankruptcy. I am sure the participants have solved all their queries. I could see that the participants had already written that the presentation was so useful that they did not ask any questions any further. So I'm very thankful to you, ma'am, for having such a knowledgeable session. I am also thankful to our principal, sir, our KLE management, my partner, Dr. Amrita Singh, ma'am, so that we were coordinating very well. Our professor, my colleagues, Professor Salim Khan and Professor Srividya, ma'am, for moderating the session. Thank you so much, ma'am. Thank you so much, ma'am. Thank you so much, Principal Sir, for guiding us, for having this third national webinar series. Thank you. So with this, we come to the end of our third national webinar series. Thank you.